The next case to come before the court is In Re IRSRMBR. You will each have 15 minutes to present your arguments. You two representing appellants will split your time. You may reserve up to 5 minutes. If you do plan to reserve that time for rebuttal, please let me know, and because I'll be keeping track of the time. The arguments are being recorded, so please introduce yourselves at the podium. Keep your voices up, remain behind the podium, and you should not use the names of children or minors or victims. You can use, as I said, initials for terms like the child or children. We have read your briefs and we're ready to proceed when you are. Would you like to reserve time?
5 minutes, thank you.
5 minutes, very well, then you may proceed.
Good morning, and nice to see you all again. I am Alan Medbeck. I'm here representing the mother in this matter. Attorney Tom Leff's here representing the father of these children. We are the appellants. In this matter, I believe I am going to speak on the bulk of these matters, and Mr. Leff will correct me where I'm wrong. I guess Mr. Raley will do that. We're here based on the trial court's decision to place these 3 children in permanent custody of some kind of children's services. I had raised 2 assignments of error. One, that that decision was counter to the manifest weight of the evidence at a clear and convincing standard. And secondly, that the evidence, testimony regarding the alleged alleged abuse presented by Ms. Schneering at trial was inadmissible hearsay, and the trial court abused its discretion in allowing that testimony to enter. The testimony at issue was the result of a forensic interview conducted by Ms. Schneering, and that is clear from the record that this is a statement and testimony taken in an abuse case from a child, and is very clearly within the scope of Evidence Rule 807 as an exception. And as such, the state, the agency, undisputedly in the court found that they had not met the burden for what's required, the criteria to have such evidence come in. That is laid out in 807A, that their particular guarantees of trustworthiness, that particularly the child's testimony could not have been otherwise reasonably obtained by the proponent, by the agency. There's independent proof of the sexual activity, and that at least 10 days prior to the hearing, the proponent of the statement had notified all parties of the content of the statement. Particularly, and the court found that there was not, that testimony did not meet the requirements of that, particularly under sections 2 and 3 in that regard. But instead of omitting the evidence, they allowed it in under Evidence Rule 8034 and as medical testimony. It's not medical testimony. It was unquestionably a forensic interview. It was done for purposes of this hearing of the trial, and as such, it was improper to allow that evidence to be admitted. And the state argues that it's both a forensic treatment, a forensic interview, and a medical treatment interview, and I would argue that particularly in this case, given Ms. Schneering's history and the reason why this interview was conducted, it was unquestionably done for determination of whether abuse had occurred and not for any medical treatment or purpose other than to determine whether there had been sexual abuse of this child. As such, if this court were to uphold the trial court's decision, it effectively guts any meaningful purpose of Evidence Rule 807. Every forensic interview of a child could be tailored to appear to be a medical case, a medical interview statutory interpretation. If there's a more specific statute, it will take precedent over a more general statute. And I think that's where we are here, that we have something characterized as a medical testimony, but in these particular cases, in child abuse cases, there is a specific criteria that needs to be met for the admission as a hearsay exception. It's undisputed, no one disputed that these were hearsay statements, but argued that they came in under these two separate exceptions. And obviously, the court agreed that this did not fit within 807. They had not met the criteria to do so, and yet allowed the agency to backdoor this evidence into the case under 8034. To do so, as I said, effectively guts 807, and also is the sole testimony for the evidence of abuse in this case. And so without that testimony, I think that we are in a different position. The clear and convincing standard would not have been met to whatever extent it was met. And we would be in a different place and not here today. So there's not a harmless error in this matter. And so as such, I would argue that this case be remanded to the trial court for further proceedings under that. Also, despite the admission of that evidence, the trial court erred in granting permanent custody to the agency because there were reasonable, less restrictive alternatives available. Particularly, there were two different sets of maternal relatives in Pennsylvania who were willing to take in these children. Obviously, the one child was continued to allow for pursuit of custody by the maternal aunt. The other children were being sought in custody by the maternal grandparents. There's testimony from the maternal grandfather that while that ICPC had been denied, it was on appeal, and they were working to correct that and to not allow more time to see if that could be done was error on the part of the court to see if that ICPC would have been available, and those parents could, and the grandparents could have been, the custodians would have been an available option, stopping short of terminating these parents' rights and legally ending their parentage of these children, which is, as has been frequently stated, considered the family law equivalent of the death penalty. And to make such an exceptional decision in the face of reasonable, less restrictive alternatives, especially, and it's important to point out that while there are these allegations raised by the one child, which we argue could not have been admitted to court, there have never been any criminal charges brought against the parent, against the father in this case. There are no claims of abuse by the mother in this case. There are evidence the mother had maintained visits, had always gone to them, had tried to maintain these relationships with these children while they were out of her custody, even under exceptional restrictions and very limited contact, part of which arose during the COVID period, but also based on concerns solely on the father. Mother has attempted to maintain those relationships and attempted to have these children placed in her family's care and custody so that she could continue to maintain those relationships. And so, with all of that evidence presented to terminate these relationships with the parents and the children was an error, an exceptional one, and I would ask the court to reverse that decision. If there are any questions on that.
Hearing none, you will have your full 5 minutes on rebuttal.
If I could have 1 minute,
Oh,
Your Honor?
sure. You can take,
I don't know. I just want to talk just very briefly to the hearsay issue and the due process issue, as I believe they go hand in hand here. I know I've set them out as different assignments of error, but the hearsay issue, as Mr. Medvik argued, is really the basis of this entire case. We have 2 young girls who are being believed. One of them is being believed by the court. One is not being believed by the court. The court said, I believe B. I don't believe S. She's too young. We don't have enough information here. She gave essentially the same kind of testimony, if we want to call it that, through the counselor. The counselor admitted, I don't know whether either of them was telling the truth. I don't care, that's for the judge to decide. As Mr. Medvick has indicated on behalf of Mother, we're in a situation where there is a rule of evidence that clearly states a matter that has been found to be a fair exception to hearsay that provides a proper manner of dealing with this issue. And if you look at the hearsay exceptions that they used, you still have to look to, is there some truth to this? What is the declarants, the children's understanding of why they're saying what they're saying? And Ms. Schneering said, I don't know. And admitted they weren't there for treatment. Thank you.
Wait, Counsel, I have one question for you.
Thank you.
What is the effect of parents agreeing to the adjudication of abuse at adjudication on this issue, whether or not this evidence should be promoted?
That is one of the tough situations here we have, Your Honor, in that if you look at the rest of my argument on due process, these parents were placed in an untenable situation. They both were being accused by the county. The county has yet, not part of, up to today is not part of the record, but up to the date of hearing was part of the record. There have been no charges ever made. No grand jury, to our knowledge, has ever been convened. Nothing has ever happened. What they've done is they've placed them in this untenable situation of, come to us, one of you. Come to us. One of you pick up the phone. One of you come down to our offices. We know who they want. They want Mother to come down to the offices and say that Father did this. I'm losing my children as a result. So they were placed in the untenable situation that they could not take the stand. They have never been in a position that they could take the stand. They've never been in a position that they could truly fight on this case and truly try to get their children back. But the county has vindicated through the due process violations, and it's due process twice, once in the hearsay, and once in just the fact that, come to us. One of you come to us. Tell us a story against the other one. Maybe you can get your child back. And that's basically what they've been doing this entire time. Thank you.
Thank you. Then I'm going to revise that on rebuttal, we have about 3.5 minutes.
Thank you.
May it please the court. My name is Rick Raley. I'm appearing today on behalf of the Children's Service Agency and Summit County Prosecutor Sherry Evans Walsh. Like Parents Council, I'll focus mainly on the hearsay assignments of error, and I believe this court should overrule those assignments of error and affirm the trial court's judgment. And I'd just like to start out by saying there's nothing in the rules of evidence that indicate that only one hearsay exception has to apply in order to allow something into the evidence. There's nothing that indicates 807 controls over 8034. They could both be applicable, they may both be inapplicable. All those exceptions are available to a party trying to put evidence into the record. And whenever I think of 807, I think of the classic example from Ohio versus Clark, the U.S. Supreme Court case on that provision. And in that, I think it's a social worker receiving a statement from a 3-year-old that he hit me. And they went through the 807 procedures there. The state did not seek to admit this under 807 at all. They only saw it under 8034. So when we look at 8034, the entire analysis focused on what's the primary purpose. And the licensed psychologist who testified clearly indicated what her purposes were. She wanted to diagnose what was going on in these children's lives and make treatment recommendations. She received this information and she did that. She has 28 years of experience. She's done 2,500 sex abuse evaluations. She was hired, she works for a third-party private company. She doesn't work for law enforcement. She does not work for SCCS. There is no indication at all that the purpose of those interviews was for trial. Now, references to forensic within the state's brief and maybe throughout the trial relate to the fact that the psychologist followed standard operating procedure for eliciting information from children to know that they understand what the truth is, what's false, the importance of telling the truth. She knows how to make sure the children understand that before they disclose to her. So I think this case falls under a very significant ambit of case law, holding that statements like this in a variety of circumstances, civil, children protective cases, criminal cases, that these are appropriately admitted by trial courts. And this goes to although our harmless error is not raised, that evidence has nothing to do with the other findings the trial court made about the condition of the home, about the quality of the mental health objectives followed up by the parents, whether the father did anything to comply with the sex abuse evaluation. None of this information were received about these disclosures related to those findings at all. I would just briefly address the maternal relatives argument as well. The ICPC application was denied. The caseworkers evaluated possible placement with these relatives. They concluded that it would be inappropriate. It would separate the sibling group, and they're all very bonded together. It would, when they observed the maternal grandparents with the children, they thought that they were overwhelmed by the number of children who were unable to care for them the way they needed to. And I think that's significant, and the trial court credited that testimony, and I don't think there's any reason for this court to reverse that on the manifest way review on appeal. So if there aren't any questions, I'd ask you to refer.
Any questions for Raymond? Okay, hearing none, thank you very much.
Thank you.
Turning that back when you're ready.
Thank you very much. As to Mr. Rayleigh's statement that the agency did not attempt to bring this evidence in under 807, I contend that that is their error and not the court's responsibility to try to make it fit in under 8034. It's wrong, it's still wrong. Regarding the statements about the sibling group and their closeness, the testimony is that these children are already not residing together. There was no family option where they would have all been in the same place, and that includes in their foster placements. At that time, the children had already been separated. Two of the girls in this at issue here were not together, along with the boys who are not at issue in this case right now. Being separated, one of the girls was living separately at the ESC, what the testimony will show. The evidence and the statement regarding the grandparents being overwhelmed, believe that that was perhaps only one time that the children were allowed to see the grandparents all together, but it was a minimal number of times, and to have an opportunity to try to establish that relationship and to see and to make that work, I think was denied these grandparents by the foreclosure of that right, to let them get into a pattern where that would have worked. So, back to the issues about Ms. Schneer's testimony. The consideration as to what the motive for the statements were, and I think that the interviews here were clearly done, not for purposes of medical care, but for a forensic interview to determine what had happened, if anything, to SNB in this case, to these two girls. As father indicates in his brief, the children were not advised or diagnosed, or that they were being diagnosed with anything. They were not advised for any kind of treatment. They were not admitted for any sort of treatment, and they were not actually referred to any outside provider for any treatment. There was no follow-up by Ms. Schneer to see if anything had happened. This was conduct to determine whether there was testimony that would relate to an abuse case, and that's where we are. And the agency at trial attempted to paint this as something else, and Mr. Rayleigh is doing a good job of trying to support that, but that is not the case. You can call it an apple all day, but if it's still an orange, it's an orange. And this is an 807 case, and this testimony that should have been excluded because it did not meet the criteria. And regarding the criteria, no one is disputing that there was evidence of trustworthiness, and no one is disputing that the interviewer was qualified to take this testimony. But the other criteria there, the court itself found was not met. So
both, all three, for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail that decision to you on the day it's released, and the opinions will also be posted on the Ohio Supreme Court website. The court is now adjourned.